Department of Public Safety here in Vermont, and it's my first time testifying here in person, although I've testified over Zoom over the years.
Yeah, Tucker, when you reminded me of that, I couldn't believe it. It was the first time we met in person.
Well, I really
like I know you well through Zoom.
Yeah, well, this is better. I like being in person better, and to have Terry Corson's cookies here is just really wonderful. So thank you for having me in this morning. You know, the conversation so far has really touched on a lot of what I'm going to touch on, but I'll offer what I have for your consideration. I really just have some additional statistics and then really just some general framing comments regarding the broad topic of conditions of release and bail. I have no specific comments today on particular bill language, although I do know that there is language out there in some bills that have already been introduced, but also some language that individuals have been working on, including some collaboration with the Department of State's attorneys and sheriffs. First, I want to acknowledge that concerns about crime from the public are borne out in the National Incident-Based Reporting System statistics, the NIBRS crime statistics for Vermont. Comparing the 5 years between 2018 and 2022, the number of incidents per year for motor vehicle thefts increased 121%. Shoplifting increased 45%. Larceny increased 45%. Thefts from motor vehicles increased 108%. Aggravated assaults increased 73%. And homicides, as we know, increased 100%. Regarding property crime, Vermont has surpassed the national average crime rate for larceny in 2022. You are more likely to be a victim of larceny in Vermont in 2022 than on average elsewhere in the United States. Regarding violent crime, as an example, in absolute numbers, law enforcement reported more aggravated assaults in Vermont in 2022 than in all of New Hampshire, which has a population more than twice the size of Vermont's. The same is also true with Maine, which also has a population more than twice the size of Vermont's. Accordingly, the rate of aggravated assault per 100,000 people is more than twice the rate of aggravated assault in New Hampshire and Maine in 2022. So crime has risen markedly through the COVID pandemic in Vermont. Official 2023 NIBRS statistics, as we know, haven't been published yet for Vermont. However, we do know, as an example, that homicides remained high in 2023, with another year with upwards of 20 homicides. And there's a WCAX article on the front page of their website today regarding the 2023 homicide statistics. Yes,
do you
Senator?
know when the 2023 data is likely to be available?
I don't know, but I have asked the director of the Vermont Crime Information Center, who interfaces with NIBRS on this, for the preliminary numbers. And the preliminary numbers he got back for 2023 account, they haven't reported them all yet.
Right.
So I think it does take several months. Precisely how long it takes, I don't know.
Okay.
But I think it will be in the spring sometime.
It would be helpful to prepare a list of questions for the crime research.
Yeah.
And I can ask him.
Send her a notice.
I just have a quick question. Do you want to put written testimony on our page here?
I can.
That'd be greatly appreciated.
Yeah.
I would like it anyways.
So, you know, as I mentioned with 2023, at least for homicide, we still have another year with upwards of 20 homicides. We may get, and I think we can expect, some post-COVID respite from the high crime numbers, but there is no sign that the illicit opioid market is abating, and the forces of supply and demand in that market are driving some significant portion of the crime we are seeing still today. Recent statistics compiled by the Vermont Drug Task Force state that drugs were identified as the primary motivating factor in 42% of homicides in Vermont in 2022 and 44% of homicides in 2023. The drug trade remains strong in Vermont in 2023, with Narcotics Investigation Unit sale cases increasing 17% in 2023 from the year before, arrests increasing 30% from the year before, and firearm seizures increasing 57% from the year before. So this is 2023 increases compared to 2022.
Can I two things, and I don't know who to get the information from, but I'd like to understand some of these statistics and how our drug task forces are currently staffed. And again, it's from my local sheriff, who's upset that he doesn't feel that our Southern Vermont drug task is at full complement. And I said, nobody's at full complement for law enforcement, but I'd like the statistics of how we're beefing up in terms of staffing of drug task force, and I think they're a great idea. The second is, I don't know who to get the information from on the Safe Streets Act, the federal, and what's available, grant-wise to both communities and the state to help deal with, that was federal, that I think was the bipartisan, one of the two bipartisan things I think they did in Washington. Yes.
I have a question, but I think it's
But do we know, so if you could identify for Ben or for either Ben, I guess two Bens here.
You don't have to worry about that.
Better than.
Ben and Ben, who to get that information from on both the safe streets as well as on where we're at with the drug task forces. And I would appreciate that. Go ahead.
I think my question might actually be for Ben, and I know we just went over this, but so under current bail law, a homicide would be a crime that is presumptively held without bail. And there has to sort of be like proof made that it would be okay to release that person on bail. Yes?
Yes.
Okay, so reforming bail laws in the way that I would like to do would not impact that at all.
Well, I'm not quite sure on how you.
Ending the use of cash bail as it is now and setting up a more supportive system would not impact those who are held without bail currently.
Right, well, because that's a constitutional exception.
Okay, that's what I thought.
Those individuals.
I want to be careful about sort of this conflation of violence with bail because we currently cannot use bail to mitigate violence, and that wouldn't change if we got rid of bail. So I wanted to make sure my grade on homicide being held without bail presumptively was correct. That was one of those
Right,
crimes
well, and
that
then
fell under.
that one would fall under, because homicide potentially carries a potential sentence of life imprisonment, so that would be 7553. And that's where we were talking about that presumption of detention if it's established. And I sent out the standard for evidence of guilt, that guilt is great.
Yeah.
So that once that standard is established, the presumption of detention arises, and then the burden flips the defendant to argue, well, and then the court has discretion to go through the 7554 factors to set bail or conditions, which the defendant would have to argue for at that point.
Perfect. Thank you. Trying to wrap my head around
That's a
this.
lot.
Go ahead.
Yeah, so these are just some of the statistics. As you know, there are others as well, but it gives some indication of where we are coming out of 2023. They're just statistics. And for painting a picture of the effect of crime on Vermont communities, I do encourage this committee to hear about the impact of crime from your constituents, from municipal select board members and others. I do recommend that you policymakers determine whether you have consensus that these trends in crime warrant a significant response, including a significant legislative response. If you do not have consensus on that yet, I encourage you to work towards developing that consensus by hearing from more people affected by these crime trends in your communities. But that's just some framing. The issue is not just the increase in crime recently, but that those who commit crimes in Vermont continue to commit crimes after they have been apprehended, arraigned in court, and released for the first offense. This is what people mean when they refer to the revolving door of Vermont's criminal justice system. As the state's attorneys were pointing out, those with two or more separate dockets account for about 58% of the criminal cases in Vermont as of December of 2023. Reducing the criminal case backlog in Vermont courts is helpful. But that will not solve the lack of meaningful pretrial tools in Vermont to intervene and stop patterns of repeat criminal behavior before a case is adjudicated. Waiting 12, 18, or 24 months to address repeat patterns of criminal behavior can be an untenable public policy when that behavior repeatedly undermines public safety in a community. Diversion and related programs are pretrial tools that can be appropriate for people who voluntarily comply with court orders and accept responsibility. Our current system handles this compliant behavior with relative ease already. The problem we are facing is responding to those individuals who do not comply with court orders and continue to engage in patterns of criminal behavior. Diversion and related programs do not solve that problem at all. Accordingly, there is a recommendation that policymakers examine the available pretrial tools we have in the criminal justice system to address this type of behavior. Right now, we do have limited tools to meaningfully intervene and stop patterns of behavior when people do not voluntarily comply with court orders. Improvements to pretrial tools can occur in the following areas. First, policymakers can consider when a faster arraignment is appropriate by examining when next day flashlights should be used for repeat offenders. Second, policymakers can revisit how violations of conditions of release are handled. Currently, violations of conditions of release are largely handled as just another offense to add to the list of dockets to be resolved months or years later. This is not effective. Violations of conditions of release could be reframed as a triggering point, first for immediately imposing more restrictive conditions of release, and policymakers can consider alternative, greater use of alternative mechanisms like contempt. And then third, for those individuals who do pose a risk of flight, which is, in the scheme of things, one portion of the concerning behavior we're seeing, policymakers can revisit the 2018 bail reforms to remove provisions that hinder appropriate imposition of bail and strengthen our existing bail statutes within the well-established constitutional limitations that we currently have. The purpose of faster intervention and reframing violations of conditions of release is to increase the legal pressure to comply with court orders and stop problematic behavior. This legal pressure may include the meaningful threat of detention. Whether there is policymaker consensus on this mechanism is worth considering. Some portion of these patterns of repeat criminal behavior are driven by untreated substance use and co-occurring disorders. The importance of an effective and timely government response is higher, not lower, in these circumstances. Legal pressure to end problematic drug use for justice-involved individuals can be necessary for some people, and addicted brains cannot necessarily wait 18 to 24 months for a criminal case to be resolved for an intervention to stop repeated patterns of criminal behavior and to obtain treatment. How do we adapt the criminal process to meet the needs of addicted brains? How do we strengthen the existing system we have to be more responsive to intervene and stop patterns of addictive behavior? Whether there is policymaker consensus on these principles is worth considering. Civil mechanisms of legal pressure for repeat offenders with untreated substance use and co-occurring disorders are also worth exploring in this area. And so here I'd just like to point out that we're all talking about the criminal justice system and the mechanisms that we have within it and the limitations of those mechanisms to intervene and stop patterns of behavior for people who've been charged with crimes. But take into account the fact that in other areas of the law, we have civil mechanisms to intervene and stop patterns of behavior that are problematic. When a child is in need of care and supervision, we do not necessarily have to arrest the parent in order to intervene and put legal pressure on behavioral change for that parent. We have a civil mechanism to do that. Right now, we don't really have a civil mechanism in Vermont to intervene and put legal pressure on individuals to change their patterns of behavior. And so we are using the backstop of the criminal justice system to do that. The tools that we have right now in the pretrial immediate time period are limited. Bail is a limited tool, but these other mechanisms like greater use of conditions release, examining whether contempt is even meaningfully possible in the pretrial space are worth considering, and we hope we could do that collectively this summer. So that's just one other consideration to keep in mind. It is perhaps a longer term consideration that might not be resolved this legislative session.
What concerns me, and I have no disagreement with what you said or nor what the governor's proposing, but I do have concerns that we can try to do this But if we don't have the tools available, for example, requiring somebody to participate in drug and alcohol treatment, residential or outpatient. If they're in Bennington, they can't get methadone unless they go to Greenfield, Mass, Brattleboro, or North Adams, Mass. And for many of them, that's not possible. Even some of them can't leave the state according to their conditions of release. Residential may not be available, so we're keeping that promise. We have nobody to supervise unless they're on home detention, nobody to supervise their release to make sure that they're following the rules. So if there were intermediate consequences available that could be put in place if they're not following the rules, we don't have anybody to supervise that. So we're setting up a system to incarcerate people. That worries me because we've made attempts since 2010 to lower the numbers of people incarcerated. And I'm really worried that we don't have once again, we have the response, but we don't have we can do the legislative. We don't have the boots on the ground, to put it bluntly. We will fail. Those are considerations that I think we have to make with whatever we do. I'm not opposed. I always thought there should be consequences for violations. Whether they're violations of conditions of release or everything, that's my makeup. I can remember when I was first running a group home for troubled youth, what I tried to teach staff was, if you don't take care of the little things, the big things will get you. So, and I always use the description of a couch. Got a little hole in the couch. No big deal, but if you don't fix that little hole, those kids will go in there and they'll start making it bigger and bigger and bigger, and pretty soon you got to replace the couch. I worry that we're not doing the stuff that we need to do on the front end, to drug treatment, supervision, et cetera, et cetera, et cetera. And that worries me. I don't have an objection. Somebody that's 47 times should be in jail if you violate conditions 47 times, even 7 times. But I do have a problem that we can't solve that problem in the communities. That's why I'm asking about the Safer Streets Acts and how we can do, more proactive and get our treatment up this time.
Yeah, I completely agree with you, and I think one area we can agree is that the criminal justice system really should be the backstop and sort of the last resort for treatments of substance use disorder and mental health care, which means we need to make significant investment in our communities, of course, in our treatment system. And I wonder, and I am doubtful anyone in this room is going to have this number, but I hope that we can find it, is the sort of average cost for a year of substance use or mental health treatment. Because my guess is that it is going to be significantly less than the average cost of incarcerating someone for a year. And so really thinking about how we wisely invest in prevention and community care, I would argue that the criminal justice system is probably the absolute worst place to be getting treatment for trauma and mental health and substance use. And so I really want to ensure that as we're making policy, we're thinking about how we make those investments in the community and in prevention.
And those are, as I said, worthwhile public policy discussions. And I suspect there'll be more of a medium-term public policy discussion. What we're considering is what we can do this legislative session to address this particular issue of people violating conditions of release. And then, so these are my, formal comments. And then I'll just conclude with, what I have left here. In my experience over the last year, kind of working in this field within the administration and participating in the Violence Prevention Task Force and under the governor's 10-point plan, the Public Safety Enhancement Team, and working with Vermont State Police and getting information from them, I do believe that crime and the illicit opioid market do pose a significant and collective problem that will not go away without changes in our current governmental response to it. To solve the problem, the best approach does appear to be through a consensus building among policymakers in all three branches to clearly identify the scope of the problem, to develop consensus on and actually implement the most effective mechanisms to address it. One of those mechanisms is more effective and timely pretrial tools to intervene and stop patterns of repeat criminal behavior through increased legal pressure. And really the timely increase in legal pressure when you do have that violation of condition of release and that window of intervention, it is a real focus. Bail only plays a role when someone is at risk of flight from prosecution. There are some cases in which those repeated violations rise to that level and create a real risk of flight. But we have to consider how we're treating violations of conditions of release, more generally, and perhaps that's an area where there's greater consensus.
I think it is. I think it is the area that is most concerned, but I'm not sure. Is failure to appear? I didn't bother to come. I fell asleep. Is that the same as risk of flight?
Well, so one of the proposals.
I mean, I'm just going from that particular statement that he fell asleep and missed the.
I see.
That might be something that's considered later. I mean, so that's part of I think the difficulty that is faced with for judges in making these determinations is that they're trying to assess that risk of flight at the outset, before the case has progressed. So that could be something that if they do fail to appear, that conditions are then changed.
I mean, the guy never leaves Bennington, but he just doesn't bother going to court. That's not necessarily a risk of flight. He hasn't flown the jurisdiction, but the court can do whatever it wants. I guess contempt is their only.
Well, and that's one of the things we're exploring is whether that can be a meaningful intervention in a timely way pre-trial. And we're looking into that, and I would welcome, taking a collaborative approach to see if that can fit in to one of the solutions. Because really,
it's a simple Google search of the individual with 47 counties, so
and Senator,
it's not like there aren't stories.
And, a record of non-appearance, I believe that's one of the things that are considered in the 7554 factors. But again, that's if they've had a case.
I don't think he's a risk of flight because he'll still be in Bennington.
Right.
But he just ignores everything the court says.
I wonder if that's an instance where more robust, pretrial supports and services, someone could go pick them up and take them to court.
Well, I don't think so in this particular case.
I mean, if he's there.
one last note, we were talking about deterrence earlier and, whether greater penalties are effective at deterring crime or really what is it? And one of the definitions that I read as kind of being an effective form of deterrence is the subjective perception of the individual of the likelihood of both apprehension and sanction. And so people are being apprehended by law enforcement, but there is not necessarily a subjective perception that they're likely to be sanctioned when the sanction is occurring in 12, 18, 24 months. And so if you want to deter people for violating conditions of release, there has to be some consequence to it. And while there may be some consequence in the final resolution of a case at the very end of the road, you still have this untenable public policy situation where people are continuing to repeat this behavior during the pendency of the case. And we do not have effective interventions right now to address it. Anyway, thanks very much for your time, Senators. I really appreciate it.
Good to see you in person.
Yes, very nice to be here.
Matt Valeria, actually Judge Zone is next. I hope to get.
So good morning.
Good morning.
Tom Zone, Chief Superior Judge. There was a few questions I heard asked earlier this morning, and if it's okay, I'll try to address them. Senator Hashim, you had a question regarding the presumption in 7553. You were making a statement. I believe your thought was that it seems as though you have more rights under the 7553A for a higher burden to be held than you do under 7553.
Yeah.
The difference is that under 7553, once the evidence has been found to, evidence of guilt is great to meet that standard, the presumption shifts in favor of detention. And then the court, I believe, as Ben said a bit ago, has the opportunity and obligation to consider exercising its discretion to release someone. In a 7553A, remember when Ben was talking earlier this morning about your constitutional right to release, you still have a constitutional right to release unless and until the state establishes that high standard under 7553A. So that's why there's the burden of proof there, because it is not a situation that there is a presumption of detention under 7553A like there is under 7553. Does that address your concern?
It does. I'll probably have another question in
That's
a minute, but yeah, thank you.
And that ties in also, Senator Sears, you asked a question about the delay when someone comes in for their arraignment, for instance, what happens? Well, the Supreme Court of Vermont has actually addressed that. And they found in a 7553A case that the court may hold a defendant without bail temporarily, pending that hearing on the evidence of guilt being great, what's called the weight of the evidence hearing. So there is the ability that once the court finds probable cause to believe that a qualifying offense was committed and the defendant committed it, that at that point the court can enter a 7553A order. However, the court is required to schedule as soon as reasonably possible that hearing on the right to bail.
And have weight of evidence.
And have the weight of the evidence, absolutely. Senator Bielski, you asked questions about evidence of guilt being great, but I won't waste your time with that now because I understand Ben sent that
It's in my
around.
email. I've
So
read
you
it.
have that. There was also some testimony this morning about, Senator Sears, you asked about how many people are on home detention. As of today, the number is 8. The current number, according to the Department of Corrections information from this morning of pretrial detainees for state of Vermont individuals is 430. That was the information we received this morning.
Different from.
That is, I don't know the difference, but it does go up and down every
It
day.
was in the 430 to 450.
Yeah, it was
I thought you said it was
430.
434 in the slide we saw, so that
Yeah.
could be the
Okay.
difference of the court's opening.
And for instance, I would note that on December 1st, that point in time, the number was 407. November 1st, it was 435. October 1st, it was 470. So that number does go up and down
Well, the date also, weekends are likely.
and holiday weekends.
Holiday weekends.
And that increases it. There was a question about, a few minutes ago from Mr. Jones about VCRs, and there should be looking at them from a contempt perspective. I think it's important to understand that under 13 VSA 7559E, a prosecution for a violation of condition of release is a criminal contempt statutorily. So that is exactly the process. Every violation of condition of release is a prosecution for a criminal contempt. So it's already being prosecuted as a contempt. And that is under the statute for the prosecutor to bring that action.
I don't want to get too far away because my question's about home detention and whether or not the changes that were made last year to sort of expand how that can be used, have they gone into effect? And have judges been educated about this?
Yes and yes. And I have testified in other committees, and what I've said there, and I'll keep saying, is I've talked to the judges. I've explained to the judges that this is an option that is available, that there has been talk about potentially removing this option, and that we should make sure we look at cases. My understanding is that there's a number of cases that judges would look at, and when they talk about home detention, so if someone's being held, for instance, on bail, and then you bring the case in and say, well, let's talk about home detention, let's order that. That case doesn't go to home detention because what that has done is it's now precipitated a resolution through a plea agreement. And so the fact that the number has not increased doesn't mean that home detention has not had a positive impact on those individuals. We can't always track that the numbers there. And during joint ledge oversight, there was discussions about that very point about, well, do we know whether they're being denied or whether they're just not being used. But one of the things that I've learned is that it oftentimes leads to resolution when you bring the individuals in. And oftentimes you come up with new conditions of release that eliminate bail. And so they might not be going from bail directly to the home detention status. Senator Sears, a few minutes ago, you asked about someone who's sitting in their couch and just not showing up for court. The definition of flight from prosecution under 13 VSA 7576 says flight from prosecution means any action or behavior undertaken by a person charged with a criminal offense to avoid court proceedings.
Okay.
And so when a court looks at that person sitting on the couch, we have to determine, are they avoiding court proceedings or forgetting about them? Because it says taken by a person too. So there's an idea that it's done intentionally. And so if it's an honest mistake, how does that fit in? And so those are the types of challenges the courts have to face. There's also been talk today about repeat violations. And Mr. Leaders Dumont said that, and the slides he put up said there should be consequences for violating conditions, that there also needs to be reduction in time between the conduct and the disposition and consequence. And I would agree with that and suggest that there is a consequence when you violate conditions. And that consequence is the prosecutor commences a prosecution for a violation of conditions. And that charge is addressed in accordance with the law that the legislature sets forth and constitutional protections. And if someone is found guilty, then there is a penalty that will be attached to that. That's the consequence. And as Ben spoke this morning, he talked about the fact that despite the belief oftentimes, and I understand where it comes from, of course, that because someone keeps violating conditions, well, they need to have bail, they need to go to jail. That's not the purpose of bail. And in fact, the Supreme Court has talked about that very issue when it's noted that in reversing a bail decision a number of years ago, that if the bail was put on someone to stop them from committing more crimes, the only way that works is if they can't post bail and they're in jail, and that's precisely what the Constitution prohibits. You cannot do that. And so the question is, how does a court respond when there's multiple violations? Well, the Vermont Supreme Court has held, and the current law, by case law, is from a case called State v. Brown, all the way back in 1978. And what the Supreme Court said was there are a number of reasons why the breach of a condition imposed for other reasons might bear convincingly on the issue of an accused's likelihood of returning to face trial. The multiplication of charges against the accused and the mounting of evidence against him might make a defendant's appearance less likely. The violations charged upon probable cause might well be probative of a lack of regard for the statutes of the state or orders of the court. That case, I can tell you, I have ruled many times sitting on the bench that when there's multiple violations, in particular cases, in particular facts, that rationale may indeed lead to the imposition of bail. But that's not every case, because under 7554, we have to consider all the factors in the particular case that comes before us. And while a goal of consistency of outcomes may be one that we try to achieve, as a society, it's very difficult to have consistency in outcomes when you have inconsistency in the input, because there's no two defendants alike, no two individuals' crimes are exactly alike, no two criminal records, and no two, all the factors. And so the challenge for the state's attorneys and what they're asking for, the defense attorneys, what they're asking for, and the obligation of the court is to assess the cases before us, exercising discretion. And I, again, recognize that a consistency, well, if someone violates, they should have bail imposed. Well, that's just not an outcome that the current law would support. We have to look at every case and apply the law specifically to those cases. And again, I agree with what Tim said. And one of his points was we need to reduce the time between conduct and disposition. And that, in my assessment, is critical. Mm-hmm. It is unacceptable to have the charges stretching out as long as they have been. What we have been doing, this issue came up, and I have spoken with the judges. I have taken the position that what we need to do is when you have someone who has multiple violations of conditions, we need to, oftentimes what can happen there is, well, judge, they have a new charge. So we need to talk about a global resolution and the case gets, if you will, put down further down the road. And we need to take a different position. We need to say, and look at cases and say, well, if there are going to be repeated violations that are deriving from an initial charge, we need to have that charge resolved. We need to be able to take steps to get the cases addressed sooner and not have them continually continue down the road. And so those are efforts that I know are underway by the state's attorneys, defense bar, and the courts, trying to make those steps.
In terms of decreasing the time, because I agree wholeheartedly that we need to do everything we can for a whole host of reasons to decrease that lag time between charges and the disposition of a case. But I imagine the backlog plays a pretty significant role in this. We had a big presentation last year about the backlog and where things were at. Where are we at now? Has that gotten better? Are we?
Can we stay tuned till Wednesday?
Oh,
I
we're both
suppose.
saying the same thing,
Oh, I'm
Judge.
sorry.
Just asked to wait till Wednesday for that.
Okay.
I can say that we're taking steps to address that. And my understanding is that we're going to be presenting that on Wednesday.
All right.
The very information. What I would note is that our clearance rate for 2023 was over 100%. Which means we're resolving and disposing of more cases than are coming in.
Okay,
So that's
I was like, wait a minute.
That's a positive step. And I think it's important to recognize that we were down a number of judges. And my hope and my goal is that after the new judges are all up and running, which should be by the end of this month, and assuming that they're confirmed, no pressure.
Thank you.
Is that about 30 days after that, I want to be able to come in and show this committee and other committees that we have made real differences in the counties where we've been able to have the judicial resources up to what we need. And because I think it does matter.
Mm-hmm.
And so I do think we're going to start seeing results. Will it be within the first 30 days? I'm an optimist. I believe the answer to that is yes. But it will be, I do believe we will be seeing those changes. And that's going to have a positive impact on many of these issues. We'll be able to have more trials, more hearings. And what do we know about trials? If you schedule them, what's going to generally happen with over 90% of the cases? They resolve. And so we will see the clearance rates also increase. And that's a positive step for society, for the public, for public safety, because the cases are being resolved. It helps the defendants move on with their lives, and it helps the victims. So it's a positive that we are gaining, we think we're gaining ground on, and we're going to continue to work to go in that direction.
Other comments, Judge? And do you want to comment on the Sentencing Commission's report on bail?
If you'd like me to, I could. Basically, I'll use the word punted. I think that's the appropriate term. The Sentencing Commission's report was that there is significant additional information that would be needed before the Sentencing Commission could weigh in on whether or not it could make a recommendation one way or the other.
Senator Bowles.
I believe you told me to bring this up with Judge Sonne. So
Yes.
The statutory question that was asked is what conditions are needed to end cash bail, not whether or not we should. And so I'm wondering if there are any suggestions that came from the Sentencing Commission about what are the conditions that would be needed.
The commission's position, as I understand it, was that it was not able to answer that very question because it believed it needed additional information to be able to properly consider and make any such recommendations.
Okay, and I read through the short, like 3.5-page report, and there's some questions there, but were those additional pieces of information specified?
There was reference to certain types of information that would be helpful to assess.
And the reason that that wasn't sought out, was that just a timing thing?
Much of it was timing, yes.
Great, thanks.
Other questions for Judge Sonne? Judge, thank you.
Thank you.
Welcome. Matt, we've got about 10 minutes. Would you rather come back?
I'll do whatever you want.
No, why don't we try 10 minutes? See what we can get.
I don't have the 45-minute
Presentation.
PowerPoint presentation that Tim had with all the color glossy pictures.
Yeah, but that was nice.
In any event, yeah, it was nice. I'm familiar with, I'm Matt Valerio, I'm the Defender General, as you know, for the record. I'm happy to answer any questions that came up that you might have for me regarding either the Sentencing Commission's report or the, anything else that has come up from the other witnesses. I think of these issues in large swaths. How do we deal with not every case, not the one outlier who has 47 cases in Bennington, or the one person who is allegedly, wreaking havoc in Addison County with, dozens of cases and the like. Those are the outliers. You're never going to really get at those until you address that individual. But I think of things in terms of large swaths. How do we deal with the vast majority of the issues that have arisen? I do believe, and we'll get to this, next Wednesday, that a huge amount of the problem that we're seeing with violations of conditions of release and the perception of this revolving door has to do with backlog issues, where we do have misdemeanors that are 5, 6 years old at this point, that are, we wonder if they'll see the light of day within the next couple of years because of other statutory priorities, bringing people, bringing incarcerated individuals to hearings and trial first, juvenile cases that also have priority within the court system, and it pushes the misdemeanor cases to the back of the docket. And so, to me, as a large swath issue, getting at the backlog is going to deal with, in my view, the vast majority of some of these symptoms that we're seeing that the public is starting to notice. The other thing is that I do think, and we all know this, and we've known this for many years, the public has a fundamental misperception about what bail is all about.
Yes.
And we can try as much as we can to educate, but people come from other states where bail is different. People just have a perception from television about what bail is about and immediately feel like anybody who's arrested ends up in jail, and that's the way it goes. And then eventually they get a trial, but they're in jail pending that. That's not what this is all about. And, everybody knows that, but the public doesn't get it. And so this leads to some of the angst, I think, that we see about bail. That having been said, this concept of the elimination of bail is one that doesn't actually even have unanimity of opinion within the defense bar. One of the things defense bar looks at is what tools do I have to be able to get my client out. Bail is a tool to actually get people out. It's a tool that can hold people in, but it works the other way too. And there are times when bail, from a structural point of view, with other pending cases that often come up, where you're looking to resolve the large swath, global resolution of some number of cases, bail allows you to get credit for time served if it's across multiple dockets. It's serving different purposes procedurally and structurally within the criminal justice system. So a complete elimination of bail would require us to look at other statutes as well to make sure that you're not causing other problems within the system as a whole.
Yeah, I just wanted to go back. What is the longest allowable sentence for a misdemeanor that's on our?
2 years.
So you're telling me that there are people that have not been charged with a crime that are serving under conditions for 5 or 6 years at this point, which is longer than they would have been if they'd been convicted.
Right, and I've made a suggestion over the years, over the last couple of years, that we take a look at the people in the system who have been on conditions for 2 years or more, who have not had a violation, and that those cases be dismissed under either Rule 48 or by another statute,
I made that
because effective-
suggestion yesterday.
Effectively, they have been under probation type conditions without the same level of supervision, of course. And frankly, for misdemeanors, it probably is about the same level of supervision. It's not a place where Department of Corrections puts that much attention for the most part, except for in domestic cases. But if those cases are cases that might be worth getting off our docket so we can get to the more serious cases. Effectively, they would never have been on probation probably for the 2 years, even if they were on probation for 2 years, if that was their maximum. But, over a period of time, if there haven't been any violations, I also have made some suggestions about there are violations and there are violations and there are failures to appeal. There are violations that exist only and that result in charges for violations of conditions of release that are only crimes because they were on conditions of release, but the activity in and of itself would not be criminal. And depending upon the nature and circumstances of those, that is one class. Then there are violations of conditions of release that result from new crimes being committed that are criminal inherently. One of the things I think that we had an opportunity there for a while, Senator Sears, you know this from Brattleboro, where we had a GPS monitoring pilot. And I think that there was so much kind of structure and bureaucracy that was like attendant to the pilot that we forgot about the real thing that worked so well, which is the recidivism rate of the people who were on GPS was under 2%. I think that is an unused option in Vermont, and that we should be looking at that, because one of the things we've talked about, and by the way, this slide that's been thrown around that Representative Lalonde actually came from 10 studies on deterrence that we provided at Representative Lalonde's request. And the interpretation of the information that we provided is sometimes interesting. I kind of agree with the slide, but I don't agree with the interpretation. The concept being, if you want to actually deter crime on the street, it's the concept of being caught. It is instant, if there's a law enforcement officer on the corner, that person is deterring people within his view from doing, because there's a possibility or likelihood or perception they're going to get caught. It's the same thing that happens with GPS, is the perception that you're going to get caught doing whatever it is.
Final two questions, Senator Bahowski, Senator Machine.
So I want to circle back as a follow-up to my previous question.
Thank you for the point about the GPS. I think that's, I'm sorry, I'm interrupting.
No, you're okay.
And as a condition of
We do things because we think it costs too much money or it gets too complicated because Sheriff X is doing it and Sheriff Y says it's okay, but Sheriff Z up in Orleans County doesn't like it.
Yeah, if we had a curfew for work and home and you're on GPS, doctor's appointments, court, whatever, I have to believe that would be an effective tool.
Yeah.
So follow up to my question about that group of people that has been on conditions for more than 2 years. Do we have a sense of how many people this is or how many dockets this is?
Well, those two very different.
Yes, I know.
One of the things we keep track of both. There are a lot of answers to questions along the way here that I could have helped with, but I didn't want to interrupt. But the bottom line is that that's a very hard number to get to, although I think we can get to it. For us, it's important. We talk about clients. People,
Yes,
right?
I'd love both.
All right. Cases, because of the way, or dockets, because of the way various prosecutors charge cases, some will charge multiple counts under one docket, Others will charge multiple dockets under one person, and it's all one incident.
Right.
And because you can charge maybe multiple crimes that arise out of all the same facts and circumstances, because you don't have an identity of elements, they're not lesser included offenses. Not that those are prevented either. And so that's kind of a hard thing to get at. But really what we'd have to look at is people who have not violated their conditions of release for a period of time. And we're almost getting to the point where people with minor felonies, 5-year felonies, or any crime that has more than 2 years have been spending years on. We have gotten to this point where people are spending years on conditions of release. And there are people who haven't violated. That might be an area that's ripe for inquiry.
Yeah, no, and I proposed a similar idea the
We're
other day,
running
so
out
I'd
of-
love those numbers.
Senator Sheep.
It was just going to be a comment and a plug for GPS monitoring. I just appreciated your comments. I talked to my sheriff, actually just a few weeks ago about GPS monitoring and the program that happened down in Windham County. I think it's a good alternative to incarceration, probably less expensive. And I think it also falls under the umbrella we've heard about earlier of having more robust and dynamic pretrial services. So I hope we can continue talking about GPS monitoring and see if we can do something about it.
Should be able to go.
Okay, I'm looking forward to next week. I have a lot more to say about